Good evening, everyone. I'm Rebecca Thomas. I'm the Head of Employment Team at 42 Bedford Row, and I'm here to welcome you to our latest webinar. As you can see from the title on the screen, Pause for Thought, Should Menopause Be a Protected Characteristic? And tonight I have the pleasure of introducing Gillian, who's one of our very experienced practitioners in the employment team, who's going to give you her thoughts on that question. A bit of housekeeping. I think Gillian's going to talk for about 30 to 40 minutes, and then after that we're going to have some Q&As. If you look towards the bottom of your screen, you should be able to see the Q&A box, so please pop your questions in there and we'll do our best to give you our thoughts on them at the end of this session. So without further ado, over to you, Jill.
Thanks very much, Rebecca, and thanks everybody for logging on and joining us for this webinar on what is certainly, where I am in Cornwall, a very wet and windy evening. But the subject, so pause for thought, should menopause be a protected characteristic? Why am I going to talk about this tonight? Well, partly because although it's slightly late for World Menopause Day, that's the 18th of October 2022, but I thought it was a really good opportunity to have a discussion about this topic, because it is very much, it seems to me, a hot topic in employment law these days for us to consider. And it's particularly following the report that was the House of Commons Women and Equality Committee report in July 2022. So still fairly recent, that identified the issue of perhaps we ought to be adding menopause as protected characteristic under the Equality Act. So the real thrust of that report, and the reason why I find it so interesting, is that it identifies what I think we all know anecdotally, that the UK has a bad habit of losing female talent. Part of that reason is potentially because of the menopause. And the question that was being posed by the report was, what needs to be done about menopause in the workplace? And one of the ideas that they came up with was that they ought to add menopause to the list of protected characteristics under the Equality Act, which would, and they also recommended that there should be an extension of the duty to make reasonable adjustments for menopausal employees. So that's why I thought we'd have a talk about it. So firstly, I think it's a hugely positive thing that it is such a popular topic at the moment and that we're having this conversation. I think we need to have a proper consideration of the issues because these matters just haven't been talked about in previous years. So, and secondly, I think hats off to our mothers and our grandmothers' generations who just cracked on with this, who expected just to get on with it and to not talk about it. But the titular question, should menopause be a protected characteristic? Is it really worth adding menopause to the list of protected characteristics? And this really is why the seminar is a bit of an opinion-based one as well, because I keep changing my mind on this, to be honest. I've changed my mind several times when I've given this talk before and even when I was preparing it today, because of course, arguably, the protection already exists under existing protected characteristics, such as sex, disability, and age. So I may be like a Tory MP by the end of this talk and totally change my mind on what I'm going to say on this. But let's have a look at the subject in a bit more detail. I'm going to have Chris Whitty moments. I apologise in relation to this talk. So please, next slide, please. Thank you very much, Sophie. Extending the list of protected characteristics. When I was looking at this talk, can you believe it's been 12 years now since the Equality Act came into 2010 came into force on the 1st of October 2012. I still think of it as fairly recent. I'm sure some of us do as well. The EQA, of course, provides protection and remedy against discrimination, harassment, and victimisation based on a very familiar list of 9 protected characteristics: age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, race, religion or belief, sex and sexual orientation. There is, of course, no pyramid. There is no prioritising list, cascading list of importance of any of those characteristics. Over the years since the Act came in, there have been numerous candidates who have put themselves up to join the hallowed lists. The first one, most obvious one, was perhaps caste. And you'll recall that caste is actually there in the Equality Act under section 9(5) as something that there might be an amendment to bring it in. It's never happened. And that sort of seems to have run out of steam now. And that seems to be since the case of Chandok and Turkey, when the EAT held that caste discrimination was capable of being unlawful under the current law. And then other potential candidates for protected characteristic status. Child in care, care leaver. Again, this is another interesting potential because there tends to be very much less favourable outcomes for those who are leaving care at the age of 18. Likewise, carer status. That would make life, I think, a lot easier for us employment lawyers. We wouldn't be looking at dissociative discrimination claims, etc. And then finally, the one that I'm really interested in today, menopause. As I mentioned, the July 22 report from the House of Commons has really put some traction behind this idea. Changing the conversation, if I may just go on to a slide, please. Thank you very much. Why is menopause at the moment getting a bit more traction? Well, part of it is, as I mentioned World Menopause Day, which I think has done a lot of good work, but also this lady here, Davina McCall. It's partly due to the Davina effect, isn't it, the last few years? You'll recall in the news, of course, that even supplies of HRT were running out after the Davina effect and the awareness that she has raised on this issue, that actually there was something that could be done, that women did not have to suffer in silence, and there was medication available that could alleviate the symptoms. But I just thought it's interesting to see what Davina has actually said, and she's been brutally frank about her experience of going through the perimenopause and menopause. I don't know if any of you have seen the documentary Sex, Me and the Menopause. I think it's still available on stream. But obviously she's been very dedicated to subsequent awareness raising for menopause. And she describes when her symptoms hit at 44. She says that she felt that she lost something of herself, that she felt that she aged about 10 years overnight, and that she actually thought she was going mad. She thought she was getting dementia as a result of her menopausal memory loss. And it was so bad that when she was on screen, she was even forgetting the names of people that she knew. So, for example, she forgot Lawrence Llewellyn-Bowen, which you might think might be a good thing. And personally, some of us might be very relieved to find that we've forgotten the existence of Lawrence Llewellyn-Bowen, but there we go. Davina is also an ambassador now for the menopause charity. And she says this, and I think this really resonated with me as well. She said, I used to think that the menopause was an age thing, but now I realize it's a woman's thing. For far too long, there's been a shred of embarrassment, shame, and fear about this topic. And this is where it stops. And I think that's partly feeds into the question that we're looking at today, whether menopause should be added to the list of protected characteristics, and why should it be? But as with any starting place, we really need to think about what are we talking about before we look at whether it needs to be added. So I just wanted to have a brief discussion about what symptoms that we're really looking at here. So menopause and perimenopause. What are we talking about when we refer to menopause? Really, we're talking about the menopause and the perimenopause together. It's a natural stage of life when ovaries stop producing eggs. It's caused by the lowered hormonal levels. So there's a drop in estrogen, progesterone, and even testosterone. Menopause itself is apparently just one day. It's when a woman hasn't had a period for 12 months. So on average, this cycle in life starts between the age of 45 to 55. Average age would be 51 for your menopause. If you reach menopause before the age of 45, that's rather insultingly described as an early menopause. The symptoms of perimenopause and menopause can be severe and long-lasting. This is already starting to ring some bells for us in the employment arena. It can last for a few months to several years. There can be both physical and mental symptoms. And of course, not all women will suffer the below, but just as a way of giving a feeling of what these symptoms are about. So there could be mental impairment, so low mood, anxiety, depression, fatigue, poor concentration, heavy periods, anemia, palpitations, difficulty sleeping, hot flushes, sweating, muscle pain, joint pain, night sweats, increased risk of osteoporosis, vulnerability to heart attacks and strokes, problems with urinary infections as well. So the most commonly reported symptoms are apparently difficulty in sleeping, concentration and memory issues, hot flushes, night sweats and anxiety. Now, as a woman and also as a female barrister, those symptoms fill me with a little bit of fear, frankly. But there we go. But looking at that list of symptoms, it's easy to see, of course, I think for us employment barristers, how menopause could fall within protected characteristics that already exist. So disability within the meaning of Section 6 and Schedule 1. particularly for those women who are experiencing severe symptoms that either last for more than for 12 months or more. So, for example, the ability to sleep, concentrate, which is obviously going to have a knock-on effect on your ability to carry out your work during the day. Those are, of course, all part of normal day-to-day activities. But some of the complications are, of course, in relation to the perimenopausal symptoms, is that those symptoms will not be there at the same level at all of the times. They fluctuate, they may be intermittent. So from a respondent employer's point of view, why does this matter if your female employees are going through this stage of life? It's a natural stage of life. Well, of course, it's clearly a matter of health and safety. But as identified by the House of Commons report, what concerns me more, and I think is more important for respondent employers as well, is that there's a demonstrable brain drain happening in the UK right now when it comes to female talent. So at a time in our lives, and that time between 45 and 55 onwards, when, quite frankly, women are at the height of our abilities, we are not well represented at the top tables in any profession. I don't have statistics there, but I think we can take anecdotal or judicial notice of that. And of course, it's not just going to be because of the menopause. It's going to be because of many factors. That's not going to be the only issue. So the other factors that we can think of off the top of our heads would be things like the gender pay gap, caring responsibilities, career breaks for children, but also the fact that at this age in lives, caring responsibilities for elderly relatives, for example, still tend to fall primarily on us women. These will all contribute. And dare I also suggest that part of the reason that the women are absent from the top tables may also be a little bit of a healthy dose of good old-fashioned misogyny. But the House of Commons report identified some interesting statistics on this. And when I say interesting, what I actually mean is terrifying. And it says this, that research showed them that there were 4.5 million women between the age of 50 to 64 in employment, and that women are these days staying in employment longer. So 64 now in comparison to 60 in 1986. And in paragraphs 43 to 47, they noted some shocking statistics. So women who suffer from one or more problematic menopausal symptoms are 43% more likely to have left their jobs by the age of 55 than those who did not, and 23% more likely to have reduced hours. And that, of course, is going to factor into the loss of female talent, isn't it? The Bupa research that fed into the House of Commons reports found that approximately 900,000 women had given up their jobs because of menopausal symptoms. That's significant, is it not? And what about actions short of giving up their jobs? So women who miss out on promotions, for example, because of their symptoms or reduce their hours and perhaps are seen as less dedicated to their roles. The report said this: the CIPD told us that a third of women they surveyed said that they'd been unable to go into work because of their symptoms. 31% of respondents to our survey told us they took time off work due to symptoms. Lost hours to sickness inevitably impacts on employers too. Bupa suggested that long-term absence from work to manage symptoms was taking an average of 32 weeks leave throughout their career, resulting in both damage to the individual's career and a huge loss of productivity to the business. So yes, it's a basic health and safety matter for the employees in question, but it's also an impact for the employers, because it seems to me that the employers are losing female talent and they're having to deal with absence management, etc. There is also an ongoing social stigma that is identified by the report, a social and cultural stigma. Unfortunately, I haven't got time during this seminar to talk about that, but that would deserve a topic on its own right. So put simply, menopause is a workplace issue. And as a workplace issue, I think my simple advice is that it needs training, it needs policy, and it needs support, as with every other workplace issue. And the House of Commons report says this at paragraph 63, which I think sums it up quite nicely. Menopause is a workplace issue. There is a legal, economic, and social imperative to address the needs of menopausal employees. We are not persuaded that a legal requirement for every workplace to have a menopausal policy would embed meaningful change, but there is much that employers can and should do to help their employees. Many of the solutions involve practical adjustments. and in allowing additional flexibility and understanding alongside fostering a greater respect and understanding of menopause. Employers who fail to support their menopausal employees or act punitively towards them leave themselves vulnerable to discrimination claims. They also risk their reputation, their ability to attract and retain female talent, and their profitability. And isn't it really, I think it's those last few words, ability to attract and retain female talent, but also profitability, I think that is really key to getting employers on board with embedding real change when it comes to menopause. But let's have a look at what the House of Commons report had to say about what recommendations they made. Well, first of all, they had a couple of damning observations about the current conditions. When it comes to employment law, the House of Commons report was actually quite brutal. They say that they don't think our employment law is actually fit for purpose when it comes to menopause. And I don't know that I would necessarily agree with them, as we're going to have a look at some of the cases in a moment. Why did they have such a strong opinion? Well, their concerns were, for example, when it comes to menopause, you can't easily fit it in one of the existing protected characteristics. So obviously, it's not pregnancy and maternity, is it? When it comes to things like direct sex discrimination, that's problematic because we need our male comparator. They were also very concerned that Section 14, so the dual discrimination characteristics, was not in force. And I can see the concern there, isn't it? Because often when it comes to menopause, it's not just sex, it's not just age, it's a combination of the two. They raised issues about the justification defence in both the indirect claims and the Section 15s. They were concerned that that essentially gave employers a way out. And I don't necessarily agree with that, because certainly when you're looking at disability, for example, if you're looking at a disability case, it's, as I think those of us that are in practice know, it's very, very difficult to justify, so to have your proportionate means of achieving a legitimate aim for your treatment of that particular employee if you haven't made reasonable adjustments. So I don't actually think the concerns that the House of Commons had in that respect are so compelling, but I can certainly see the concerns they've raised in relation to direct sex discrimination, to the Section 14 not being implemented. They also raised concerns about shoehorning, as I see it, shoehorning menopausal cases into disability. Their concerns were that there's a bit of a chilling effect. If you're describing what is a natural stage of life that all women are going to go through as a disability, you're essentially shoehorning it into a protected characteristic for what it's not really made for. And nor does disability help us for the sort of intermittent symptoms that may be occurring during perimenopause, because that's not going to fit easily in the description of disability. So having identified those sort of problems with our current system, what did they suggest? Well, they suggested some quite radical recommendations. Firstly, the government should produce model menopausal policies to include how to deal with sick leave, flexible working, reasonable adjustments. And of course, we all know that policies themselves don't solve anything. So unless there's training, proper implementation, and essentially a regime change in the workplace, having a paper policy which simply gives lip service isn't going to do anything. Second recommendation that they made is to implement Section 14 of the Equality Act, i.e. to have dual discrimination. Thirdly, and this is really where I'm interested in my talk tonight, they recommended that menopause is added as a separate protected characteristic. And in doing so, duty to make reasonable adjustments would also apply. Now, that is a really interesting idea, because that would be really useful for flexible working, reducing hours, working from home, etc. Something that since the pandemic, we know is perfectly doable in most workplaces because we had to. So those are the recommendations, but is it really necessary to add menopause as to the list of protected characteristics? Now, the chair of that committee, who is Caroline Noakes, clearly thinks so. She says this. She goes into full girl power mode. The omission of menopause and a protected characteristic under the Equality Act is no longer tenable. given that 51% of the population will experience menopause. Menopausal women have been mocked and maligned for too long. It is time that the government seizes the opportunity to enact change. It is time to support and celebrate these women. So I think she's very much on the same page as Davina on this. I do query where she gets the 51% from. I said that might explain the difficulties that I've had with online dating, but there we go. But we certainly know that this is an issue that affects at least 50% of the working population. So looking at the remedy and really trying to drill down is, do we need to add menopause to the list of protected characteristics, or is it just applying lip service? It seems to me that the real proof of whether it's needed is whether we look at the existing protected characteristics and see if they are providing sufficient remedy to look at how effective a remedy it is, as it has been in menopausal cases. And it seems to me, and this is where I've been a bit of a rotating Tory MP, that this is the rub of the seminar for me. There are very few reported successful cases involving menopause discrimination. Now, this could, of course, be that we have an amazing discrimination-free workplace. Now, I think those of us who are discrimination lawyers in the UK find that that's a little bit doubtful, because personally, I find that's very unlikely. It may be, of course, that claimants are being put off bringing claims in relation to menopause, feeding into the factors that I discussed a few minutes ago. So, for example, the concerns about describing menopause as a disability, the chilling effect of trying to shoehorn a claim in, essentially. It may be, again, that the House of Commons is right. Maybe our employment law as it currently fits is not fit for purpose, and we do need to add menopause as a protected characteristic. Again, that's a possibility. What was interesting is that the report also quotes some of the ELA analysis of the Employment Tribunal statistics. So from February 2017 through to August 2021, where there was a total of 78, just shy of 79,000 Employment Tribunal decisions published during that period, only 44 mentioned menopause directly. So the ELA considered that it was likely that claims were not being brought by women for numerous reasons, which appear to relate to, for example, claimants being unwilling to embark upon stressful litigation, or inability, of course, to access or to fund legal advice, because, of course, in relation to menopause claims, because of some of the factors we're going to look at in a moment, they're not straightforward under the existing protected characteristics. But that's quite shocking, isn't it, that actually there's only 44 mentioned directly. So that does tend to suggest, doesn't it, that possibly the remedy is not currently working, or certainly that the protection there is something is not quite, the message isn't trickling through. And that feeds into my experience from researching this seminar. And I've only really got a handful of cases that I'm going to talk about, because that really seems to be all that is out there. And most of those cases are recent. So that's got to be the Davina effect, isn't it? That's got to be the fact that I think, thankfully, we're getting to a stage now where awareness is being raised and these cases are being brought. But if I'm going to answer my question, does menopause need to be added as protected characteristics, simply based on the cases that we're going to go through, am I able to satisfy myself that the current law provides us with sufficient remedy? I'm not sure that I am. So let's have a look at these cases and see what you will think. And I look forward to the Q&As at the end to see what you think. But just before I get to those cases, I wanted to, again, raise where I think we probably just need to think about the backdrop of the law. Also, incoming cat. So the current law, we know that there's no dual discrimination. Of course, we know the types of discrimination that we're looking at under the Equality Act. So we're looking at we've got to put these claims as either sex, age, or disability. So direct, indirect harassment, victimization in Section 15. And if we're looking at, for disability claims, look at Section 15 and reasonable adjustment claims. What is striking, again, and I think this is an awareness issue, is that there is the absence of guidance. So there is no guidance from the Equality and Human Rights Commission on menopause. There is no guidance from the Health and Safety Executive. So, and this is strange, isn't it, despite the obvious health and safety issues that we've just been talking about and we've been looking at. It's somewhat surprising, isn't it, given the number of women that are affected and in the workplace today. There is, however, now very useful guidance from the ACAS called Menopause at Work. And I would recommend that, certainly for those of us that advise respondent employers. It seems to me that that is the best starting point for any advice for employed clients. It highlights practical, helpful steps for an employer to take, including training managers, developing a menopause policy, health and safety checks at work for menopausal employees or in their workplace. So I just want to highlight a few of those take-home points for us to think about when we're looking at the cases as well, because I think it's helpful. So first practical point, carrying out health and safety risk assessments on menopausal employees, of course, with their consent in the workplace, looking at factors such as the temperature, the ventilation of the workplace, where it's a workplace where uniform is required, looking at the material, the fit of the uniform, if there is one, whether it makes the menopausal employee feel too hot or cause discomfort, whether there is somewhere suitable for the employee to rest if needed, for example, a quiet room, whether toilet facilities are easily accessible, whether there is a good supply of cold drinking water available, whether managers and supervisors have actually been trained on health and safety issues relating to the menopause. And in relation to menopausal policies, the ACAS guidance, again, is pretty good and practical. And it says that and I like this, having a menopausal policy can help everyone in the organisation understand what the menopause is, how it can affect people, how it affects everyone differently, and what support is available to staff affected by it. The policy should cover the following. So explain what training is provided to managers, supervisors and team leaders, so the employees don't have to have those cringe-worthy conversations because they actually know that their managers and their team leaders have been trained. It's also going to assist managers, isn't it, from having, if you've been trained, as to how they can support and hopefully minimize the embarrassment factor of having the conversations with their employees. Explain who is a point of contact for queries relating to menopause issues. Show that the organisation is open, trained to talk sensitively about the issue. And the ACAS practical guidance that they say that employers should be looking at is making allowance when supporting staff through the menopause, because everybody's experience is going to be different. There was a long list of symptoms, but not every woman is going to experience that. Employers should ensure that they have reviewed their health and safety and wellbeing policies to make sure that they are joined up approach in relation to the menopause. So that means that we need to be reviewing not only diversity and inclusion policies, so our sex, race and disability, gender policies, also our flexible working policies, absence management policies, sickness reporting policies, etc. Now, talking about the sickness reporting issues, the ACAS guidance is really helpful on this, again, on practical, because as we know that trigger points are and sickness absence management is a common area for indirect discrimination claims. Because the menopause can be long-term and can affect everybody differently, managing absence from work needs to be handled sensitively. So employers should keep talking to the staff about any changes that will help them and be prepared to make those practical changes to help staff continue to work. So be it working flexibly from home, reducing hours, etc. And also consider whether any performance issues might be because of menopausal symptoms, but do it in a sensitive way. So not in the sort of, the old school awful way that we used to have about periods of, if people were talking, you'd have that awful, is it the wrong time of the month, love sort of approach. Not that approach, please. And when somebody is off sick because of the menopause, ACAS actually recommends that this should be treated similarly in line with disability-related illness. So essentially to have menopause-related absence. So that I thought it's a bit of a whistle-stop tour through the ACAS guidance, but it's really helpful and perhaps puts into frame for us where the following cases either are going wrong or where they've got it right. So looking at the cases that we have on menopause, says it's only really a handful. There's a few appellate cases and there's some first instance cases. Now, putting my devil's advocate hat on for a moment, most of these cases actually demonstrate that the existing law that we have and our protected characteristics is sufficient, because a lot of these cases are about the correct application of existing well-known principles. Sorry, just been pointed out. Sophie, if you don't mind, if you could just come on it, catch up with me a little bit on the slides, please. Sophie, if you could just Yes, perfect, lovely, successful cases. Let's looking at the appellate level first of all. So I think many of us will have heard of the Rooney and Leicester City Council. So menopause of itself is not a disability, but the symptoms may meet the statutory definition. The EAT held in that case that the tribunal had given insufficient reasons and had erred in striking out an employee's claim at a preliminary hearing that her menopausal symptoms amounted to a disability. I think those of us in practice again would think, that was a pretty brave employment judge that did that at preliminary hearing stage in any event. And again, this is an example of a case that seems to me that's about the correct application of first principles that we already have in relation to existing discrimination and disability principles, in particular about emphasis on what an employee cannot do, instead of getting confused and hung up about what an employee can do. So the facts of Rooney, if you're not aware of them, are this. This is a preliminary hearing on disability status only that was considered by the EAT. Rooney is a social worker. She brings claims of constructive unfair dismissal, direct disability and sex discrimination due to her severe menopausal symptoms of harassment and victimization. She was taking HRT. She was under the care of a consultative menopause clinic. She suffered from hot flushes, palpitations, sweating and anxiety, night sweats. Her symptoms led her to forget events such as meetings and appointments. She would lose personal possessions. She would forget to put the handbrake on the car or to lock the car. She would leave the iron on, cooker on, leave the house without locking up, etc. So they were clearly significant symptoms. She was also, like many women in the prime of her life, a carer for her husband and also for her elderly mother. The symptoms in question were that the tribunal were looking at were from approximately August 2017 to when she resigned in October 2018. So I think immediately a few of us are ringing alarm bells when you look at the description of those symptoms and you think, well, that's more than 12 months. Hang on a moment, what on earth is going on there? But nonetheless, her claims were dismissed on the basis that she wasn't disabled due to her menopausal symptoms, and the tribunal, the judge found that her symptoms were actually fairly trivial. Really? I think if you were experiencing the list of those symptoms, would you describe those as fairly trivial? But there we go. It does seem somewhat surprising, and I think the EAT say precisely that. The EAT say that the judge erred in focusing on what the claimant could do, and in this case it was about the fact she had caring responsibilities, rather than what she could not do. And they failed to give reasons, particularly why the symptoms were not long-term or significant, and was remitted back to the ET. I think that makes sense, doesn't it? When we look at those symptoms, that we've already got more than 12 months of symptoms there. We've got symptoms, we've got both physical and we've got both mental symptoms that appear on the face of it to have a significant adverse impact. So sent back to the tribunal, and Ms. Rooney was held, I think was found to be disabled subsequently later in 2022. So that seems to be a straightforward case of existing disability principles being correctly applied, focusing on the day-to-day substantial adverse effect on activities, looking at what a person can't do rather than their coping mechanisms and what they are capable of doing. So the other case was an unsuccessful one. This EAT case, Scottish case, Gallagher and Abellio ScotRail. This is February 2020, unsuccessful. G brought claims of unfair dismissal, disability discrimination, so section 15 and reasonable adjustments. It's actually quite an interesting read on itself, because it's an interesting case where, despite the fact there was absolutely no procedure whatsoever, it's one of those rare cases where dismissal in those circumstances was found to be within the range of reasonable responses. It's very fact specific. In terms of the menopause, it was accepted that it was disability, but knowledge was in dispute. And possibly this is where there are some more nuanced arguments in relation to the protected characteristics, because we know, don't we, as discrimination lawyers, it's not easy to get home just on a concession that disability. We've got to get home on knowledge, we've got to get home on substantial disadvantage, etc., for reasonable adjustments claims. So knowledge was in dispute. And I think this is a case that demonstrates the difficulties of satisfying all of the limbs of the disability definition. So G was employed as the head of customer delivery standards. She had been there for 10 years. Her symptoms were, the disability relied upon with symptoms of menopause and also depression. She was dismissed without any procedure being followed. following disagreements with her line manager, T. So the disagreements start in November 2014. There's a series of issues until 2017. So there's disagreements about salary increases. There's disagreements about the fact that G is put on an on-call rota. G also disagrees with T about who should be recruited to a position. G is off sick for 7 weeks. And then there's further disagreements between her and her line manager at a return to work meeting. She has in January 2017. In March 2017, she has a one-to-one meeting in which a deteriorating relationship with her manager is discussed. She accepts that she doesn't behave like that to anybody else. And her direct line reports also express concerns about her leadership abilities and about the support that she is providing to them. At this stage of time, so we are in March 2017, the respondent business was at a critical stage of affairs financially. The business was reporting a trading loss. And basically in April 2017, G pushes along to her appraisal meeting and unfortunately is dismissed at that meeting because of breakdown in relationship between her and her line manager. She does not dispute that there was breakdown in that relationship. She's offered a right to appeal, but doesn't appeal. And her EDT is May 2018. She claims that the line manager had a negative impact of view of menopause. There is a reasonable adjustments claim, and the PCP is a rather bizarre one. And again, I think us employment lawyers will remind ourselves how important it is to get that PCP right. The PCP is that not to have a breakdown in relationship. Well, that just doesn't work as PCP for me, but there we go. So the tribunal found that it was not about disability, it was about SOSA, some other substantial reason. The reason for the breakdown in the relationship had predated the claimant's menopausal symptoms. And they found essentially in relation to the knowledge point that there was no actual constructive knowledge. Her line manager had no knowledge of the symptoms of the claimant's menopause or further knowledge of her depression. And indeed, the claimant herself was unaware of her own symptoms until about November 2016. So by that point, the relationship and the issues have been breaking down for about 2 years at that point. And at no point did the claimant herself attribute her behaviour to her menopausal symptoms. So this is a case that on appeal, the EAT said that obviously in relation to dismissals without any form of procedure, we need to be super, super, super careful. We need to exercise extra caution. The tribunal were entitled to conclude that the procedure in this particular case would not have served any useful purpose. And it's an interesting one because they actually say that had the tribunal found as finding a fact that had there been a procedure, it actually would have made things worse. Okay. So there we go. This was a case of 2 senior managers who needed to be able to work together closely at a critical time for business and were completely unable to do so. So the tribunal were entitled to conclude that any procedure would actually have worsened the situation. As I've mentioned, the EAT conclude that the tribunal were entitled to find there's no causative link between the behaviour complained of and the disability. So no details, for example, were provided of any substantial disadvantage in relation to a failure to make reasonable adjustments claim, nor was there further detail given of the longevity of symptoms or the substantial adverse impact on day-to-day activities. Indeed, this is a case of a claimant who was inclined to underreport her symptoms, as was illustrated by an occupational health report. So the EAT was of the view was unlikely to, so an occupational health report was unlikely to add anything to the procedure. So that's what we have at the EAT for menopause cases. I think we can all agree that's not an awful lot. There's a handful of first instance cases, which obviously are not very helpful to us for precedent wise, but are useful to see. And I think they back up the anecdotal evidence that there are more cases of menopausal discrimination cases on the horizon, partly due to the increased awareness that we have been talking about. First one is the oldest one I could find, Merchant BT PLC. So back in January 2012, this is a capability dismissal for poor performance. And I think this is actually quite an interesting case for how it's a case again where it's about the application of proper principles that we all know and love from unfair dismissal cases in dealing with capability cases. So again, it's not one that necessarily cries out for menopause to be added. So employee is dismissed for performance. She says her performance was affected by menopausal symptoms. Sophie, could you change the slide, please? Yeah, with that, yep, no, we're on the right one. Good for merchants, thank you. So this said it's application of good old-fashioned principles. So claimant, when you actually look at the facts of this case, you can see why. Claimant was employed by the respondent for 24 years when she was dismissed, latterly as a learning and development trainer. She had had no previous performance issues. She is put on a performance plan by one manager and dismissed by another. She starts underperforming and being put on PIPs from 2009. She is dismissed in March 2011. So on the face of it, a respondent employer might think, well, we've not exactly rushed through a procedure here. But the key point and takeaway from this is what goes wrong at the dismissal stage. The claimant expressly raises with the dismissing officer that she's suffering from menopausal symptoms, but the respondent employer, through its dismissing officer, makes no further investigation as to whether it could have impacted upon her performance. And for those of you that, if you go on and have a look at the case, it's at paragraphs 56 to 58, but I'm going to read them out in full because they are absolute corkers and show why I say that this is about first principles not being applied properly here. So paragraph 56 says this. So D is the dismissing officer. I think it's Mr. Douglas. D determined that because his wife had gone through the menopause and because his HR advisor had also gone through the menopause, that notwithstanding his difficulty in assessing the significance of the information provided to him by the claimant's GP, he knew enough and that no further investigation was necessary. D accepted in evidence that before dismissing for poor performance linked to health, it would normally be important to have as much information as possible to understand the condition and what the prognosis was. This is consistent with the respondent's policy in relation to the management of underperformance. D provided no proper explanation for not referring the claimant to occupational health at this juncture to ensure that he had a properly informed understanding of his health issue and how and whether it impacted on performance and what its prognosis might be. D accepted in evidence that he had no knowledge of when the claimant's menopause had started, whether HRT had been prescribed or whether it might have assisted. D could provide us with no explanation for his failure to do what he accepted he would normally do when an underlying health issue became known to him. Beyond that, because his wife and his HR advisor had themselves been through the menopause. So essentially, here we had what sounds to me a quite insufferably know-it-all manager who knew everything about the menopause because his wife had been through it. So pity his wife and pity the dismissing officer because, not surprisingly, that was an unfair dismissal. But it seems to me, isn't that just, although when you read that evidence, it's shocking and perhaps illustrative of how menopause is treated in some workplaces, but isn't it just basically the principles that we already have in place being applied properly and should have been applied properly to that case? The next case, Sophie, can you move on the slide, please? Actually, if you can go one more on for me. Yes. Yeah, I'm going to go for this one first of all. 2018 case, so we're coming forward in time. Davis and Scott and the Scottish Courts and Tribunal Services. Isn't it just a little bit embarrassing that one of the practical examples that we can look at in relation to menopause discrimination actually takes place in the court system? But here we go. This was a Glasgow Employment Tribunal case. Claimant is a court officer. She's successful in her unfair dismissal claim and in her Section 15 disability claim. And in fact, there's an order for reinstatement made. And of course, for those of us in practice, we all know how rare it is actually to have an order for reinstatement made these days. And again, it is, however, a case of application of familiar principles. So claimant had worked for the court service for 20 years. Again, so long-standing employee. She suffered from menopausal symptoms for 2 to 3 years. And her particular symptoms included very heavy bleeding. So she was suffering from flooding type bleeding. She became severely anemic. She felt fuzzy, emotional. She lacked concentration. There was an impact on her memory. She was put on HRT, but the heavy bleed throughs remained severe, and they were so severe that she had to change her sanitary protection twice an hour. She told the respondent she was put in a court where she had easy access to a toilet and was permitted to take toilet breaks whenever she required. But the actual dismissal facts are these, and this is gross misconduct dismissal. So she was taking medication for cystitis, which was, as I mentioned at the beginning of this talk, the issues with urinary tract infections, something that can increase during perimenopause and menopause symptoms. So she would put her cystitis treatment into a water jug at her table in court, and she put that in, and she was intending to drink it during the day. When she came back from a break, she noticed that her water jug had been moved, and she was concerned that 2 male litigants in the courtroom had actually been given that water jug. So she notified those male litigants that there was potentially medication in the water. She declined, because she was in open court, to tell them exactly what that medication was, because she was embarrassed. And she did indeed she raised her voice during that conversation. It actually turned out that the claimant had not put her medication into that water, because had she done so, the water itself would have turned pink. But she's dismissed for gross misconduct, and she's dismissed for gross misconduct for not taking proper care of her medication and knowingly misleading the respondent and its health and safety team and the 2 male litigants that they had ingested her medication. She accepted that she had intended to take her medication, and she said that she could not remember whether she had done so. And she was saying that that was because of her menopausal symptoms. But the respondent believed that she had lied about the medication being in the water, which is a very strange conclusion to reach, frankly. So disability is conceded. The tribunal find that her conduct was affected by her disability. She suffered one of the something arising from her disability was her memory problems. She would become confused, and in this particular case had become confused as to whether she put her medication in the water. The situation caused her to advise the 2 litigants that they may have consumed water with medication in, and also caused her to become more anxious and to raise her voice as a result of the situation. None of the respondents' witnesses were able to explain why the claimant would have lied about the medication being in the water. So in those circumstances, it seems to me it's not surprising that dismissal was found to be, of course, unfavourable treatment. If the claimant hasn't lied, and there was absolutely no grounds to conclude that the claimant has lied, trust is not broken down. So that is why the claimant was able to be happily reinstated. It seems to me, again, that is a case of application of the existing principles that we already have in disability and in unfair dismissal being applied to the facts of those circumstances. The previous slide had A and bon marché. I'm not going to ask Sophie to go back to that slide, but I'm just going to tell you briefly about that, and I'm anxious that time is ticking on. A and bon marché Limited is 2019 case, in December 2019. Again, A had worked for her employer for about 10 years. I think she'd been in retail for 37 years. She was subject to numerous comments about being menopausal from her younger male line manager, CB. She was successful in her claims of sex and age discrimination. However, this case is of limited value to us when we're actually looking at the question for tonight's seminar, because the respondent had gone into administration. So essentially, they don't put up any evidence. So only the claimant gives evidence. So the tribunal, as it were, has got a one-sided perspective, although the tribunal does test that evidence and apply the law to it. So claimant says she'd originally got on well with her younger line manager, but things changed from 2017 when she goes through the menopause. He would make comments calling her a dinosaur. He would intervene when she was dealing with customers, when she was with them. He would accuse her of not being able to do simple tasks like staple a document together. If she was having any difficulties, he would say things like, "Are you menopausal?" Those sort of dinosaur comments. He would constantly say to her, "Why don't you apply for work elsewhere? Why not go for part-time elsewhere?" And in a restructuring exercise, although she was the only person pulled for her particular role, he had encouraged other employees to apply for her position. that's particularly nice, I think you'll find. And when the claimant asked for simple adjustments in the workplace, such as the temperature to be adjusted on the shop floor to help her assist with her hot flushes, he said, no, it's not a problem for me. All of the above led the claimant to suffer, unfortunately, a breakdown. And the tribunal, obviously, faced with no conflicting evidence, found that course of conduct took place. They found this was a course of conduct over a substantial period of time, and it caused the claimant to become more ill. So, as I said, that is a case that is there, but it's of very limited value to us. The next case that I wanted to talk about is the case of Donachie and Talent Technology. Again, this is a disability case, PH, and this has got our very own and able Eleanor Wheeler appeared for the respondent in this case. Unfortunately, she came second, and this was a preliminary issue to consider whether the symptoms of menopause were amounted to disability. But I don't think that any of us would be surprised to find that they did on the symptoms described. So the claimant was relying upon menopausal symptoms, including anxiety and problems with concentration, and also Raynaud's syndrome. The issue was actually about whether there was substantial impact on the normal day-to-day activities. And the facts are these. So from July 2017, claimant starts to experience hot flushes, which become intrusive and disruptive. They're occurring about 10 to 12 times a day. She experiences palpitations and anxiety and sleep disturbance. As a result, she suffers from fatigue, memory, and concentration difficulties. In December 2018, she is prescribed HRT, and that improves her symptoms, but the symptoms persist, particularly if she's under pressure. So she says that her day-to-day activities are affected, her sleep is disturbed, she needs more rest after she's carried out physical activities. In comparison to premenopausal symptoms, she's unable to attend the gym both at midweek and during the weekend. She finds that she has to rest more at the weekend to recover from the week. She finds that she is distracted during conversations and tasked by the hot flashes. She has to rest a lot. Her weekend activities are curtailed and reduced. And she finds that her use of computers, reading and writing all slows down because of her difficulties of concentration, leading from the sleep disturbance. The judge finds in those circumstances that had she not been prescribed HRT, her symptoms would have continued at the same disruptive level that they had prior to December 2018. And it's not a surprise, really, that given that level of symptoms, the judge finds that she was disabled and says this: I see no reason in principle why typical menopausal symptoms cannot have the relevant disabling effect. The description of the potential impact of symptoms on day-to-day activities seems to me particularly relevant to the claimant's situation. I have little hesitation in concluding the effect of her menopausal impairment on her day-to-day activities is more than minor or trivial. The range of her daily activities and her ability to undertake them when she would wish with the rhythm and frequency she once did is markedly affected as set out above, and would have been even more so were she not taking HRT. So that is another disability, a case where disability as a protected characteristic has worked in favour of the claimant at the preliminary stage. And then I wanted just to raise, so if you can go for the next slide, please. Case of Kaunaka and textbook teachers. Very proud to say that, again, of the small handful of cases I have, it's another member of our employment team, and it's Max Gordon this time, who appeared for the claimant successfully. This is a direct disability discrimination and failure to make reasonable adjustments claim, and harassment claim in relation to disability. The direct disability discrimination cases and the reasonable adjustment case doesn't succeed, but the harassment claim in relation to disability does. But it is, to be fair, it is more of a cancer case. The reason why I flag it up is that it's just interesting to have in our back pocket, if nothing else. So the claimant was employed as a recruitment account manager from June 2017. She's diagnosed with breast cancer in May 2018. She goes off in work in June 2018 for surgery for treatment, and then ends up, I think it was a resignation, but certainly there's the dismissal stage. The disability-related harassment is very fact-specific. It's about who said what in a number of telephone conversations. So there is no wide reaching impact of it. But as far as the menopause impact on it, one of the comments that is made by the managing director in June 2018 was it's no big deal that the claimant is going to be forced into a surgical menopause at the age of 37 and would be unable to conceive children naturally. So that's one of the comments that was found to be disability-related harassment. And then finally, just as a very late entry to the handful of menopause cases that we have, the wonderful Jason, who's on top of all things employment-related case law, helpfully reminded us that in the group today, there's a recent case of Kelly and DWP. This is another case where the first instance tribunal find that there's no reason at all why menopause should not constitute a disability, depending on the impact on the particular case. But they were not satisfied that that particular claimant was disabled by reason of her symptoms of menopause. She had not established that there was substantial adverse impact on her day-to-day activities. And this was a case where this lady was dismissed for accessing the Searchlight database, which is a very secure database. And it wasn't because of something in relation to her disability. As I said, there were interesting questions there that might have arisen in relation to the longevity of her symptoms, because she had actually stopped taking HRT or had a break in HRT at the date that the conduct took place. But nonetheless, the tribunal in that particular case does not look at the issue of knowledge or look at the Section 15 questions either, because they find that she is not disabled by the duration of her menopausal symptoms. So I'm conscious that that's actually taken me an hour to go through those cases. So Sophie, can we go on to the next slide, please? Where do I think we are at and the way forward? Going back to the beginning, do I think that the menopause needs to be added as a protected characteristic? I said, I keep going 360 on this, going through those cases again, looking at the difficulties that we have presented to us by trying to shoehorn menopause into disability, particularly. I think there is a good argument for adding menopause to the list of protected characteristics, even though those cases, the other way, and looking as devil's advocate, do suggest that the principles are there, and when they're properly applied, certainly related to disability, menopausal cases can be successful. But the very fact that we've only got such a short list of cases that are successful would suggest that the remedy isn't really working, wouldn't it? So, and we know from the ELA research, we know from the House of Commons report that there are lots of reasons potentially behind the fact that we have so few cases, but it is very telling that there's just a handful of cases. So yes, I think adding menopause to protected characteristics is potentially something that would address that issue. It would, I think those cases also show the shortfalls, particularly when pleading or looking at defending cases in relation to disability. It is still quite difficult to apply all the correct limbs of the disability test. So we need to look at also make sure the evidence is there for substantial adverse effect, longevity, knowledge, particularly when it comes to substantial disadvantage and causation. So having menopause as a protected characteristic in its own right would naturally get round to those problems. However, being realistic about it, despite the July 2012 2022 report, I think the government is very unlikely to implement any of those changes, as it seems to be much more hell-bent on removing employment law rights at the moment, particularly in relation to the retained EU law. So getting rid of little pesky things like TUPE and paid holiday rights, rather than looking to add menopause as a protected characteristic at this stage. So I think despite the increased awareness, menopause claims are going to, for the foreseeable future, likely to have to be continued to be shoehorned into the existing protected characteristics for some time to come. I think it'd be really helpful if Section 14 was implemented, so we could have dual discrimination, because as I said, it's not just sex, it's not just age, it's a combination of the two. So advice for respondent employers: how do we protect ourselves against such claims? Training on the ACAS guidance, bringing in those menopause policies, properly embedding them in the workplace culture. I think that will help protect us moving forward. And then finally, my little cartoon there, I don't know if you can see it, It's very, very difficult to find a joke about the menopause that is not, quite frankly, patronizing or a bit cringeworthy. So the best that I could come up with to leave us on a slightly more cheery note is this, that you've got two hens there, one who's happily knitting away, producing eggs, the other one is not, and says the poor girl is out of eggs. The pig is saying it's the menopause. So I can leave that one with you there, and hopefully throw open the floor. I appreciate that we've been an hour, but if there are any questions, any burning questions that people have arising out of my thoughts on this topic, Becky and I will be more than happy to assist. Thank you for listening.
Thank you very much, Jill. That was very interesting. We have had some questions, some which can be answered more quickly than others, I think. We had a question about what's happened in Rooney and Leicester, and I think the answer is that it was remitted for a preliminary hearing in February this year, and it was found that the claimant was disabled by a combination of menopause symptoms and stress and anxiety, but I don't think there's been a final hearing on that yet.
Interesting. What exactly are the reasons for not adding menopause to pregnancy and maternity? Tidiness?
Yes. One question we had here, and I'll read it as observation as well as a question, I think. It seems that even if you did have a standalone protected characteristic for menopause, surely you would need criteria similar to those in section 6 to determine whether the menopause qualifies for protection anyway. Otherwise, simply reaching a particular stage in life would qualify for protection irrespective of whether the individual actually experiences any adverse effects. It might not be ideal, but is it not the case that what we're talking about is the actual effects of menopause and whether they might meet the definition of disability?
Precisely. I mean, that's why disability, it's a difficult test, isn't it? But why it's such an important thing, isn't it? Because we have it's got to be substantial adverse effects. So that means that it wouldn't be open to everybody to argue, and to perhaps, looking at it from a respondent's point of view, wouldn't be open to everybody. It wouldn't be open to abuse, just to reach a natural stage of life. But we also have to balance that with what is described as the chilling effect. And I think that there is a real chilling effect, isn't there? Having to describe something as a disability, having to go through those hoops. Necessary, I suspect, to make sure that the protected characteristic is not being abused, but also very off-putting to describe something as disability. As I mentioned, there are limitations, because particularly in relation to perimenopausal symptoms, they may be intermittent. They may not tick all of the boxes all of the time, but they can still be having a significant adverse impact on day-to-day activities when they are live, which might require reasonable adjustments in the workplace. So it's a give and take situation, isn't it?
Yes, and improving it may be interesting. One of the findings in the Kelly case that you referred to, that's just been handed down, was an observation that in that case the claimant stopped HRT, but after that she had not visited her GP, which was one of the factors the tribunal noted.
But that's a two-edged sword in itself, isn't it? Because if you think about how we don't visit, so you haven't visited the GP, which obviously normally we're arguing a disability would suggest that you're not disabled, because if your day-to-day activities were being adversely affected, you would be going back to GP. So that's where the argument is on that, isn't it? But how about the fact that you just simply don't have time? You've just got to crack on with it, and you are coping. But that doesn't necessarily mean that your normal day-to-day activities are not being impacted. So, for example, if you're disturbed, if your sleep is disturbed, you are absolutely shattered. But frankly, you haven't got time because you're picking up the kids, you're looking after elderly relatives. You just have not got time to make that GP appointment, and you're just getting on. That doesn't necessarily mean that you wouldn't be able to demonstrate that your normal day-to-day activities are not being significantly adversely affected. So,
another question here. How would you define menopause, given that different women do not suffer? Is it open for abuse for women of a certain age who make a mistake to blame it on menopause?
Ooh, that's a
controversial question there, I suspect.
Yeah, a brave question. How would I define it? Well, wouldn't we be defining it as I did earlier? So you'd be talking about these, I think we are going to be looking at some sort of disability type. You'd be looking at adverse symptoms, but you'd be talking at those adverse symptoms would have to be coming from, be perimenopausal or menopause, which has its meaning and can be defined. It's easy enough to define that, isn't it? It's not as if it's something that isn't medically provable. It is. So yeah.
And probably you have a similar, it's a diagnosable
yeah, exactly,
medical state. So
yeah.
And then the effects are going to be the matter that's tested. I suspect in the same way they might be in a stress and depression type case. Interesting one from Choi. What's your view of the possibility of introducing menopause leave akin to maternity leave? A good thing or too difficult to apply, she asks.
I don't necessarily think that we need menopause leave. I think menopause related leave. So rather than actually having to send a cringeworthy email going, I'd like to go off on menopause leave, please. I think the way that the employer treats the sickness that is taken is important. So I think that is something that we should be doing. You know, in the same way that we, in relation to disability related, that's a special category and is looked at differently when it comes to trigger points. I think the same should be there for menopause rather than introducing a menopause leave as such, if that makes sense.
Yes, lovely. Well, we've got a tiny bit over time, but I think it was worth it for those interesting questions. So thank you very much, everyone who's joined us this evening. Our next seminar is going to be on the 18th of January, and we're going to be talking about anonymity in tribunal proceedings, another interesting topic. So hopefully we'll see some of you then. And just remains for me to say thank you very much, Jill. That was really interesting.
And thank you very much for putting up with my ranting about the subject. Take care, everyone, and see you all again soon in person, I hope. Bye. Bye.